Welcome to the next edition of our Constitutional Crisis Seminar Series. We're very fortunate to have Professor Ilya Somin with us today. Professor Somin is a professor of law at George Mason University and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. His research focuses on constitutional law, property law, democratic theory, federalism, and migration rights. He is a prolific writer. In addition to writing many academic articles, he's the author of 4 books and co-author or co-editor of 2 more. I'll just mention 4 of them: Free to Move, Foot Voting, Migration and Political Freedom, Democracy and Political Ignorance, Why Smaller Government is Smarter, and The Grasping Hand, Kelo versus City of New London, and the Limits of Eminent Domain. Plus, he's co-editor of a book on eminent domain, A Comparative Perspective. He is a regular contributor at Reason.com via the Volokh Conspiracy, where in addition to arguing for constitutional fidelity, he takes what I would call a very principled and consistently libertarian perspective on issues like taking, foot voting, and the harms caused by restrictive laws, such as zoning and licensing of trades and profession. Now, Professor Somin is not just a scholar and a very significant public intellectual, although that ought to be enough for anybody. He's also an effective advocate in court. He's been involved in litigation concerning the Trump tariffs since its outset. His recent victory in the federal circuit will be reviewed by the Supreme Court in an expedited calendar, which will have oral arguments sometime during the week beginning November 3rd. Meanwhile, the tariffs remain in place. We are very, very fortunate that in the midst of all this, Professor Somin found the time to come and talk to us about the Trump administration's assertion of emergency powers to raise tariff. Professor Somin, I'm going to mute myself and turn it over to you. And again, thank you for doing this.
Thank you so much for having me. It's an honor, especially when you look at the impressive list of the other participants in the seminar. As I see it, it's always good to be the least famous and least prestigious person on a speaker list because it's better than the opposite situation. And sort of that's my situation with this particular seminar. What I'm going to do in this presentation is I'll first start out by describing what the Trump tariffs are. Then I'll talk about our case and other litigation involving the tariffs and where that litigation stands, and then I'll go into the reasons why these tariffs are illegal, because we have a whole bunch of them, and many of them have broader, important implications. Then at the end, I'll talk about 2 broader issues that this litigation raises. One is the issue of judicial review of emergency powers. How should that work? How deferential it should be and the like. And the other is the implications of this kind of unbounded tariff authority for the rule of law more generally. So first things first, what are the Trump tariffs? Over the last few months, since March and April, Trump has imposed the biggest trade war and the highest tariff rates since those that contributed to the Great Depression. And he's done almost all of this under the International Emergency Economic Powers Act of 1977, which doesn't actually even mention tariffs. And these include the so-called Liberation Day tariffs, which impose 10% tariffs on goods imported from almost every nation in the world. On top of that, announced at the same time, are the so-called reciprocity tariffs. I say so-called because even though they're called reciprocity tariffs, in reality, there's nothing reciprocal about them. They're imposed even on many countries like Switzerland and Israel that impose 0 tariffs on U.S. imports into their own countries. And yet still, nonetheless, some 50 or 60 countries are subject to these reciprocal tariffs. Then, in addition, we have the so-called fentanyl-related tariffs imposed on China, Mexico, and Canada for the supposed purpose of combating the import of fentanyl from those countries to the United States. And more recently, we have additional IEEPA tariffs. The International Emergency Economic Powers Act is known as IEEPA, and I'm just going to use that term from now on because it's much easier to say than the full long name of the statute. So we have 50% tariffs recently imposed on India. We have tariffs imposed on Brazil, in part because Brazil is prosecuting Trump's political ally, their former president of Jair Bolsonaro, because he tried to launch a coup to stay in power after he launched an election. And there are also tariffs against the European Union and others, all imposed under IEEPA. IEEPA says that the president has the power to, quote unquote, regulate certain types of international transactions if there is a national emergency, and that emergency involves a, quote, unusual and extraordinary threat to the American economy, national security, or foreign policy. And he has used this law, which had never previously been used to impose any tariffs at all, to impose what is by far the most extensive trade restrictions over the last 80 or 90 years. All told, the Tax Foundation estimates that the new IEEPA tariffs would impose some $1.8 trillion in new taxes over the next decade and reduce GDP growth by 0.7% per year, which is a lot. Recently, the Yale Budget Lab estimates that within the next year or two, it could push an additional 600 to 800,000 people into poverty because obviously the price increases disproportionately affect poorer people, especially when we're talking about price increases for basic goods like food, clothing, and the like. So our case, which was initially brought by the Liberty Justice Center, a public interest firm, and myself, we have 5 clients who are U.S. Small to medium-sized businesses that import from many of the affected countries. And our case only targets the so-called Liberation Day tariffs, the 10% tariffs on every country in the world, plus the associated quote-unquote reciprocal tariffs, which again are not actually reciprocal at all. We filed our case in the Court of International Trade, which is the court that generally speaking has jurisdiction over statutes related to trade and tariffs. We won there, and then we won again just a couple weeks ago in the U.S. Court of Appeals for the Federal Circuit, which is the nationwide appellate court that has jurisdiction over various issues, including appeals from the Court of International Trade. Consolidated with our case is a case filed by 12 states led by the state of Oregon. They too are challenging the Liberation Day tariffs, but unlike us, they're also challenging the fentanyl tariffs. And both the Court of International Trade and the Federal Circuit ended up striking down the fentanyl tariffs as well as the Liberation Day tariffs. There are a number of other cases challenging the Trump tariffs, the IEEPA tariffs. Some are in the Court of International Trade, but they're sort of backed up right now, awaiting the resolution of our case. There are others that have been filed in other courts because there was a jurisdictional question whether these sorts of cases belong in the Court of International Trade or whether maybe they belong in the federal district courts. And to make a long story short, some plaintiffs like us decided to file in the Court of International Trade. Others went into district courts. In most of these district court cases, including one filed by the state of California and another filed by members of the Blackfeet Nation Indian tribe, the court said, well, this should be in the Court of International Trade, but there is appellate litigation going on over whether that is in fact the case. But in one of them, the Learning Resources case filed in the District of D.C., there the District of D.C. ruled it did have jurisdiction and also ruled the tariffs are illegal. So there is still this sort of outstanding jurisdictional issue potentially hanging over the case, but I won't go into great detail on that issue because it's extremely boring and annoying. Right now, as you probably know, the Supreme Court has granted cert in our case. It has on an expedited schedule. Our case remains consolidated with the case brought by the 12 states. It is now also consolidated with the Learning Resources case, where in an unusual move, the Supreme Court granted cert on that one as well, even though that case hadn't even been resolved yet in the D.C. Circuit Court of Appeals. But essentially, that case will now be to just go straight up to the Supreme Court. So presumably, I don't know this for sure, but presumably the Supreme Court will resolve both the jurisdictional issue and also the substantive questions as well. So now I think for perhaps the really important part of the presentation, or at least a really important part, which is why these tariffs are highly illegal. And there is a whole bunch of reasons why. We've got like 6 or 7 of them, depending on how you count, and we only got to win one. So one is just very simple. The word tariff or impost or duty or any other synonym for tariff just isn't mentioned in the statute at all. It talks about just regulating various international transactions. It talks about prohibiting them, but it doesn't talk about imposing taxes or tariffs. So we argue that this simply doesn't allow for tariffs or any other kind of taxes. It only allows for other kinds of regulations and restrictions. And indeed, if you look at the Constitution, there's 2 separate powers for regulation or legislation on international economic relations. One is the Foreign Commerce Clause, which, yes, you guessed it, gives Congress the power to regulate foreign commerce, but there's a separate power which allows the imposition of imposts and duties, which are sort of 18th or 19th century terms for what we would today call tariffs. In the Learning Resources case, the District of D.C. ruled for the plaintiffs precisely on that basis. In the federal circuit, they ruled in our favor and that of the 12 states, also in large part on that basis, though only 4 judges reached the issue of whether the word regulate allows any tariffs at all. And the other judges in the majority, they said, well, it at least doesn't allow these broad sweeping tariffs, and we're not going to fully resolve the issue of whether it forbids any tariffs of any kind, because we don't need to, given the enormous sweeping nature of these tariffs. So then we also have an argument that tariffs related to trade deficits are properly covered not by IEEPA, but by Section 122 of the Trade Act of 1974. This is sort of a technical argument that I won't get into too much unless people are really interested, and we can talk about it in questions. Further, let's assume that tariffs are allowed, at least in some cases. Then there is the issue that IEEPA can't be used at all unless there's an emergency and, quote, an unusual and extraordinary threat. There is nothing extraordinary about trade deficits whatsoever. We've had trade deficits for decades. They go on all the time. And moreover, they're not even really a threat. When we have trade deficits with a particular country, that just means we value the goods that we import from them more than we value the money that we spend. And it so happens, they don't value our goods as much, or simply, as in many cases, they have a smaller economy than we do, and therefore simply just can't buy as much as we can. So it turns out Lesotho, a poor African nation, is one of the countries that's subject to these IEEPA tariffs. Lesotho is extremely poor and has very little ability to buy much from us, but they produce diamonds, which cannot be produced in the United States, at least not the kinds that they have. So it's totally understandable that we have a trade deficit with them, and it's not somehow harmful or unusual or extraordinary or a threat, and it's not an emergency. I have to confess that, I have a huge trade deficit with my local supermarket. I buy things from them all the time, and they virtually never buy anything from me. If you know anybody who works for a Safeway supermarket, tell them they need to buy more of my books. But the fact is that, my trade deficit is not unusual or extraordinary. It's not a threat. It's not an emergency. It simply means that I value the things that I buy there more than I value the money, and it follows the principle of comparative advantage, which is sort of the basic economic idea that each of us, we try to make things that we're good at, we're relatively to the available options, but other things we buy from other people. So instead of like having a farm in my backyard or my own herd of cattle or whatnot, when I want to buy some meat or some food or many other types of goods, I go to the supermarket or to another store. And similarly, there are goods that Canada, Mexico, Lesotho, and so on, they can produce better or more efficiently than we can, or in some cases, they can't even be produced in the United States at all. Our lead plaintiff in our case is VOS Selections. They produce wine, or an import wine. I know very little about wine, but those who do know, they tell me that there are certain kinds of vintages, like many of the ones that our client imports, that simply cannot be grown in the United States because we don't have the right type of soil or climatic conditions, and therefore countries like France, Italy, and others, they have a comparative advantage in producing that type of wine, and it makes sense for us to import it rather than to try to replicate it ourselves. There is a stronger argument, perhaps, that the fentanyl is somehow an unusual and extraordinary threat. But again, illegal drug imports are a standard consequence of the war on drugs and of alcohol prohibition before it. There's nothing unusual and extraordinary about that either. And moreover, as the CIT ruled, even if there is a threat here, the tariffs on that do not, quote unquote, deal with the threat because, of course, the importation of fentanyl is already illegal. So tariffing other goods doesn't do much to stop it. You can argue maybe it might leverage the Canadian and Mexican governments to do something about it. But even there, it's unlikely much could be done. The importation from Canada is infinitesimally small, accounting for something like less than 1% of all fentanyl imported into the U.S. From Mexico, it's mostly done by U.S. citizens bringing stuff in back after they go to Mexico, where you can't realistically expect the Mexican government to stop U.S. citizens from returning home. And indeed, if they tried to do that, we would be rightly angry and would object vociferously. So not only is it not an unusual and extraordinary threat, but the tariffs are not actually dealing with that threat either. Though I would note again, the fentanyl tariffs are not part of our case. They're part of the state case, though I personally happen to agree with the states on that issue, even though it's not part of our case. But let's assume that the tariffs are at least to some extent authorized and that perhaps there's some ambiguity about whether there's an emergency or an unusual and extraordinary threat. Then there is still the issue of the major questions doctrine. Many of you may have read this in recent Supreme Court decisions. The Supreme Court has said repeatedly that if the executive claims that there has been a delegation of a power to the executive by Congress to address some kind of major economic or social or political issue, that at the very least that delegation has to be clear on the text of the statute. And the Supreme Court has used the major questions doctrine in recent years to strike down a number of sort of broad assertions of power, usually by the Biden administration. For example, the administration claimed to be able to forgive over $400 billion in student debt using a questionable interpretation of emergency powers. They claimed they could impose a nationwide eviction moratorium during the COVID pandemic and also a COVID vaccination mandate affecting over 80 million people. And in each of those cases, at the very least, it was ambiguous under the statute whether this power was actually granted the executive, and so the major questions doctrine was applied to say, no, if you're going to claim a power that sweeping, then it has to be clearly stated under the statute. And this is probably the biggest major question that anybody has ever seen. I previously thought that the $400 billion in student loan forgiveness was the biggest one, but even that looks small compared to this, which in terms of the amount of money involved is several times as large. And that's not even counting the enormous economic and social impact of higher prices, reduced productivity, more people going into poverty, damaging foreign relations with our allies, and so forth. So if anything is a major question, it is this. Now, the administration have a couple arguments. They say, well, major questions doesn't apply to foreign affairs. I don't see any reason why there should be such an arbitrary limitation. But in any event, tariffs are not a pure matter of foreign affairs because they are massive tax increases on Americans. Despite what the administration likes to say, they know perfectly well that the taxes are in fact paid by American firms that import, like our clients. That's why our clients have standing in the case, because they've been paying these tariffs. And there is a massive domestic economic impact. So this is not a pure matter of foreign affairs. In addition, you could try to say, well, it has a foreign affairs impact, therefore it's foreign affairs. But the same thing is true of most other major policies, including ones that have been declared to be major questions before. Obviously, efforts to combat the pandemic, they were in part because the virus was coming into the United States from abroad, and the efforts to combat the pandemic clearly had an impact on U.S. foreign policy, but that it didn't exempt it from major questions. In West Virginia versus EPA, the Supreme Court struck down under major questions some Biden policies on global warming. Obviously, combating global warming is an international issue. It affects the whole world. That didn't prevent application of the major questions doctrine, and so on. There's also the argument that, well, major questions doctrine applies to delegations to agencies, but not delegations to the president directly, and IEPA and its tax delegation to president. I think this argument also doesn't make a lot of sense. It's been rejected by every single circuit court that has ruled on it, including the federal circuit in our case. But also, this totally doesn't make sense if you believe, as the current administration clearly does, that the executive is a unitary body under which the president should have total or near total control over everyone else in the executive branch. If you believe that, then delegation to an agency are ultimately delegation to the president, who, after all, is the agency's boss. And furthermore, if you argue that the issue is a matter of accountability, that the president is more accountable than an agency, that doesn't hold a lot of water, because Congress certainly can cut the agency's budget or even abolish the agency entirely, whereas it cannot abolish the presidency entirely, though at times I wish that maybe it could, but that power doesn't exist in the Constitution. So in that respect, the president is actually less accountable to the legislature than an agency is. There's other problems with this distinction as well, and I can talk about them in questions, but basically it doesn't really hold a lot of water. Let's say, however, you somehow get past the major questions doctrine and all the other arguments I mentioned at this point, you conclude that these tariffs are authorized, then you have another big problem under constitutional non-delegation. Because if you accept the administration's arguments and all these previous points that I've made, then the end result is that under IEPA, the president has the power to impose any tariffs he wants on any nation for any reason at any time and keep them going for as long as he wants or lift them for as long as he wants, and so on. He has already made all kinds of adjustments, lifting the tariffs in some cases, lowering them in others. So non-delegation is the idea that there are limits to how much legislative power can be delegated to the executive. The Supreme Court, at least until recently, has never been tremendously clear on exactly what those limits are. But if you believe there are any limits at all, then the limits have to apply here. In a situation where there is a textually enumerated congressional power, which the executive is claiming has been almost completely delegated with no meaningful limitations to the executive, such that they can impose anything they want at any time, regardless of the amount and so forth. Therefore, this would then be the biggest claim delegation since the Schechter Poultry case in 1935, which some of you may have read in constitutional law class, which in the National Recovery Act of 1933, that act had delegated to the president the power to set regulations and wage and price controls and the like for nearly the entire non-agricultural economy. The Supreme Court unanimously said that was going too far. This is a delegation almost on par with that. And if anything violates the non-delegation doctrine, this should. I think this conclusion is reinforced by the Supreme Court's recent decision in the Consumers Research case just this past June. That one did uphold a delegation of power to the FCC to impose some fees on on internet broadband service providers, but it also said that there are constraints that apply. One is when there's an imposition, or there's a delegation of a power to impose taxes or fees or the like, there have to be, quote, floors and ceilings. And the court ruled that in that case, there were floors and ceilings. In this case, if you buy the administration's position, there is no floor and no ceiling. There's no limit to how much tariffs can be imposed or for how long. And there's not a minimum floor, I guess, either. Similarly, the court said that there have to be tighter, clearer standards provided by Congress when the delegation is of a power to address a major issue that affects the entire economy, as opposed to a narrowly technical issue. This very obviously affects the entire economy. If this doesn't, I don't know what does. So it violates that stricture as well. And in an interesting passage in the majority opinion, Justice Elena Kagan says, well, hypothetically, if the FCC's fee setting had been limited to $5 trillion in fees, while that would be a hard limit, it wouldn't be enough because it would leave so much enormous discretion. Here, there isn't even that $5 trillion limitation. There's no limitation at all if you buy the administration's position, because the administration position is that the requirement of an unusual and extraordinary threat, that's just left to the executive's unilateral determination that such a threat exists. And if that is to be the case, then all you have to do is just say the words unusual and extraordinary threat, and we have one. We can in the oral argument in the trial court, one judge said, well, if there's a peanut butter emergency, the president says that's an unusual and extraordinary threat, a peanut butter shortage, then could you impose tariffs for that? And that's actually less ridiculous than what is actually being done, imposing tariffs for trade deficits, which, unlike a peanut butter shortage, which would be a genuine problem for the many people that love peanut butter, trade deficits are not actually a genuine problem at all. Therefore, our position is that if there are any meaningful teeth to the non-delegation doctrine at all, and the consumer's research decisions suggest there are and should be, then those teeth should apply here. If the administration prevails on these other kinds of issues, obviously they don't need to reach non-delegation if they give us even one of those previous issues. And that brings me to sort of the final argument, which is the argument of constitutional avoidance, though I should mention that with regard to non-delegation, as with regard to major questions, there are these arguments that non-delegation doesn't apply to foreign affairs, and I have the same responses that I made before. This is not really a matter of foreign affairs, and moreover, it's not clear that there should be this double standard of sort of looser scrutiny, when something is related to foreign affairs in some way. So the constitutional avoidance doctrine, what that says, if you look at cases like NFIB versus Sebelius, the Obamacare case, is that if a court is presented with competing interpretations of federal statutes where there is a plausible interpretation that does not raise constitutional problems, then you have to choose the one that doesn't raise them over the one that does. And here you have like the mother of all non-delegation issues that would arise, as I just described, or instead the court could rule in our favor on one of several statutory arguments that no tariffs are allowed at all, that there's limits on the kind of tariffs that are allowed, that there's no unusual and extraordinary threat, or that the major questions doctrine requires a ruling against the government here. If we win on any of those, that would avoid the constitutional problem, whereas if our position on those gets rejected, then the constitutional problem, stares the court in the face, and they would have to decide the big non-delegation issue. So, I'm not perhaps the world's biggest fan of this avoidance canon, but it's strongly embedded in precedent, and courts apply it on a somewhat regular basis, and it seems like it should be applicable here. In the federal circuit, as I noted before, the 7-4 majority ruled in our favor on the idea that either there's no tariffs at all authorized by IEEPA, or alternatively, at the very least, that the tariffs are permitted by the word regulate or severely limited. They also ruled in our favor on major questions. A concurring opinion says no tariffs are authorized at all, and also that we should win under non-delegation. There are dissenting judges who, the four of them, they held that there is an unusual and extraordinary threat, not necessarily from trade deficits, but from the effects of trade deficits on manufacturing and defense and the like. Obviously, this issue remains outstanding. I would merely note that there's nothing unusual and extraordinary about the current situation of American manufacturing. Indeed, we actually have much more manufacturing than we did 10 or 20 years ago. You can argue we should have still more, but its current state is not unusual or extraordinary, nor is there anything unusual or novel about the argument that we need to reduce imports in order to bolster manufacturing, though it's questionable whether reducing imports really actually does have that effect, because a lot of imports are actually inputs into manufacturing, and therefore a lot of manufacturers are actually suffering from these tariffs. Lastly, I should mention another issue that is often raised in the public debate about the legality of these tariffs, but it doesn't come up as much in court. And that is the argument, well, what about these deals that Trump has made with various countries using the IEEPA tariffs as leverage? I would simply say that those deals cannot make legal tariffs that are otherwise illegal. If some foreign government has agreed to a deal based on those tariffs, that government's actions cannot legalize a power grab by the president. Moreover, if we do want to have trade deals with other countries, the Constitution outlines a way, namely that if those deals are going to become law, they have to be approved by Congress, like numerous previous trade agreements with other countries were, like the NAFTA and USMCA trade agreements with Canada and Mexico, for example. So these deals do not have any meaningful legal effect, and the deals are actually harmful because they leave the tariff schedule much higher than it was before. So American consumers and businesses are still suffering much more than they would if we simply went back to the status quo before these deals were made. In the last part of the presentation, I wanted to talk about a couple broader issues that these cases raise. One is the issue of judicial review of emergency powers and how deferential it should be. It is often said that in reviewing IEEPA and other emergency powers issues like the Alien Enemies Act, which I've also written about, that the court should defer because the presidency has special expertise and the executive needs to be able to act quickly in emergency. As you can probably guess, I fundamentally disagree. The whole point of granting extraordinary powers in emergency is that they can be used in these narrowly specified extreme circumstances, but they can't be normalized. They shouldn't be used all the time. And indeed, the framers of IEEPA, the Congress that drafted it, said, the whole idea here is that, this is to deal with extraordinary situations and not for, quote, a normal state of affairs. If you allow the executive to just be able to announce an emergency or an unusual and extraordinary threat, or in the case of the Alien Enemies Act, an invasion or the like, then you can just normalize this use of dangerous, extraordinary powers. And the broader and more sweeping the power is, the more dangerous its normalization. Second, I don't think deference to expertise is warranted here, because if you have a genuine emergency or a genuine invasion or an unusual and extraordinary threat, frankly, you don't need any specialized expertise to detect it. You don't need specialized expertise to know, for instance, that Vladimir Putin's invasion of Ukraine was an invasion. That's just very obvious. On the other hand, it's also obvious under the ordinary meaning of the word invasion that illegal drug smuggling or illegal migration, or whatever you think about those things, they are not invasions. And similarly, it's pretty obvious that trade deficits are not an unusual and extraordinary threat. Maybe they're a problem, but if they are a problem, they're sort of a normal ongoing policy problem and not anything unusual and extraordinary. If you have to have convoluted legal arguments to show that a supposed emergency or unusual threat or invasion exists, that's a strong sign that your argument is wrong, or perhaps that you're being disingenuous about the argument in the first place, and that the argument is just a pretext for doing something else. And that brings me to another reason why deference in such cases is inappropriate, and that is, maybe deference might be appropriate in a case where genuine technical expertise is the real motive for the action being done. But it's very obvious in this case and a number of others that there is no genuine technical expertise being used, that the claimed expertise is just a pretext for policies policies that are being pursued for other reasons. So I would argue for just a generally non-deferential policy towards invocations of emergency powers. But at the very least, if you don't want to go as far as I do, you should at least say that there should only be deference when the evidence strongly shows that there really is technical expertise in play and that is the reason why the emergency power was invoked, as opposed to just being a pretext. Some people divide these issues into deference about the meaning of the words and the statutes versus deference about the existence of facts. And it could be, the judiciary should not defer on the meaning of the words, but should defer on claims that, say, an invasion or an unusual and extraordinary threat properly defined actually exists. To my mind, there shouldn't be deference on either. A fundamental function of the judiciary is to determine not just what the law is, but whether it fits the facts out there. Like, think about a murder case. One question is, what does the statute banning murder mean? But another is, did Smith actually kill Jones, as the government claims? Similarly here, there is an issue of what is an unusual and extraordinary threat or an emergency, but there's also an issue of whether the facts fit, and that also is something that judicial decision makers should be able to determine. Otherwise, the government could get around limitations and emergency powers simply by, as in effect, lying, making up bogus facts, and just saying, well, an invasion exists even if it doesn't, an unusual and extraordinary threat exists even if it doesn't. Even if you trust the current president not to lie about such things, which I don't, you probably then don't trust the next president, who may be a Democrat. I don't trust any of them. I think there's a long history of politicians lying for various purposes and overclaiming their powers. And therefore, when there is a claim of extraordinary authority of the kind that is dangerous and can only be invoked in an extreme situation, I think the burden of proof is on them to show that that extreme situation actually exists. In a situation where it does, meeting that burden should be pretty easy to do. And if it does not actually exist, then that's all the more reason to not let them get away with the power grab. The last point I want to briefly talk about is the implications of all of this for the rule of law. If you ask, 3 different law professors what the rule of law is, you'll probably get 4, 5, or 6 different definitions. The concept is obviously contestable and means different things to different people. Nonetheless, I think one definition of the rule of law, an intuitive one, is that we contrast the rule of law with the rule of man, or the rule of just one person being able to make decisions based on his or her whims. So a rule of law is one where legal rules, at least important ones, are set down in advance by the legislative power. They're clear, they apply equally to everybody, and they can only be changed through appropriate legislative processes. At the other extreme is the rule of a despot or a king or the like, where he or she just gets to do what they want. They wake up on the wrong side of their bed. They can impose new tariffs or regulations or other rules on people. Then, if they have a better night of sleep the next night, they can lift them or modify them and so forth. And of course, the rule of one man is precisely what we are getting here under the administration's interpretation of IEEPA, where he gets to impose, in his view, any tariffs he wants on any nation for any reason. That is pretty obviously not the rule of law. It leaves room for lots of favoritism. There's already studies that show that the much more limited tariffs imposed under other statutes during Trump's first term, that they tended to be imposed more heavily on firms that donated money to Democratic candidates than those that donated to Republicans. And the example of the Bolsonaro IEEPA tariffs is an example of them being used to help Trump's political allies and the like. And there's obvious room for abuse of power here. Moreover, businesses like our clients, consumers, investors, and others, they need stable rules to be able to plan purchases, investments, organize their lives and their enterprises and so on. And if the president can impose any tariffs he wants at any time, there is no stability there. We don't know what the tariff schedule is going to be tomorrow, much less a year from now or 2 or 3 years from now. So there's a practical aspect to this as well. When you have the rule of one man as opposed to rule of law, that is also economically damaging. There's a lot of development economics literature which shows that to be the case. And these policies take us a major step in the wrong direction, or at least they will if the courts allow them to stand. Much more can be said about these issues, but I've already gone on for quite a bit, so I'm happy to turn it over to your questions. Thank you so much.
Well, thank you. That's absolutely terrific. Before we go private, I would just want to ask a few follow-up questions to sort of flesh out a couple of the things you said. And one of them is based on the dissent. Now, if the power to regulate includes the power to block importation entirely, why shouldn't it be seen to include the lesser power to limit importation via tariffs?
I think because these are not a greater or lesser included power, these are two different powers. One is a power to block trade entirely. The other is a power to impose massive taxes, including on American citizens. The framers deliberately separated these two powers and treated them differently. And they particularly were suspicious of the executive being able to claim the tax power because of the abuses of 17th century English kings like King Charles I, who had done actually something very similar to what Trump is doing here. He had tried to use what was known as the ship money authority, which is a kind of emergency power to impose taxes to raise money to combat potential naval attacks and invasions and the like. That was supposed to be an emergency power to be used only when invasion is threatened, but he started using it as a sort of all-purpose source of revenue that could be imposed whenever he wants. This is actually one of the things that precipitated the English Civil War and later the Glorious Revolution. And this experience led the framers to treat the tax power differently. In addition, a blockade is something that might be used in a genuine emergency when you really have an enemy nation, that is threatening us in a serious way. Whereas incremental adjustments about tariff schedules, they're more a matter of normal policy and therefore should not be dealt with the same way.
So if I hear you right, you're saying the power to tax may be the power to destroy, but the power to destroy is not the power to tax.
Not all forms of destruction are part of the power to tax. That is right.
All right. The next thing is pretty technical. But at one point in your argument, you say, well, the facts are just really clear here. So, implying there's nothing that can't be decided on summary judgment. And you gave us an example. You don't, in one of the papers you wrote for Reason, I think, that you don't have to be an expert to understand that Russia's assault on Ukraine is an invasion, or that the COVID pandemic was an emergency. But is that right? I mean, doesn't this current administration actually dispute both of those things?
Yeah.
So maybe they're not such.
I would say two things about that. One is the person who declared COVID an emergency was actually Donald Trump. So to my knowledge, he has never said that he was wrong to do that. It is true. He has said that, he's attempted to deny that, that Putin invaded Ukraine. I think he's just obviously blatantly wrong about that, and he's just lying. And so I never said that nobody would ever deny things that are obviously true. That people do sometimes deny things are obviously true, but when they do that, we can point to the overwhelming evidence, such as 150,000 Russian troops attacking Ukraine and trying to take over its territory, and say that is very obviously an invasion. And anybody who says otherwise is either ignorant or lying.
And the last one is really totally different. It's a policy question, maybe, or something. So supposing the plaintiffs in this case win, right? The Supreme Court rules all the tariffs illegal. They still have been running for months with major economic disruptions and high fees. And to the extent that the costs are passed on to consumers and other third parties, as I understand the law, and please correct me if I'm wrong about this, there is no legal requirement for refunds by the people who pass tariffs on to their customers. And in fact, in the main, this seems moderately unlikely, at least in many cases. Is there something fundamentally wrong with a system that allows this? Should it be reformed? Can it be? How?
So this is a broader question that sort of doesn't fully, not all of it is within my expertise. I would say two things. One is, as I understand the refund system, and I'm not an expert on it, so I could be missing something here. I'm not on this case because I'm an expert on tariff refunds. I have to totally admit that. But as I understand it, which I could be wrong, but the only people who could claim refunds are the importers who paid tariffs, like our clients, for example, and therefore if costs were passed on to consumers, or if consumers and others suffered damage simply because of transactions that were foregone, right? Like if the price is too high, you might not buy it at all, even though you would have bought it, if the price was lower. You can't get compensation for that. I don't see an easy solution to that other than, we did argue that the court should grant this an immediate injunction and not hold the injunction in abeyance until the appellate process worked itself out. The courts ruled against us on that, and I obviously disagree with those rulings, but there's not a lot that I can do about it. More generally, what we should do, I have other notions that go beyond this case, such as, when government officials do unconstitutional things and inflict harm on people, they should be personally liable, and there should be little or no qualified immunity or other kinds of immunity. So, for example, in my ideal world, Trump, Bessent, and other decision makers who behind these tariffs, they should be personally liable for imposing them. That wouldn't cover all the damage, but that would help deter such action in the first place. But we don't have that system, obviously, and courts don't grant, or preliminary injunctions as much as perhaps they should. Or in this case, we did actually get an injunction, but then it got stayed. So this is an example of how the system does not work as well as I at least think ideally it should. Though, of course, the other side of this debate would say, well, this would deter, useful exercise of government power. I say, don't threaten me with a good time. I think most of these types of exercise of government power are actually harmful and damaging, and only in the rare instances where there's overwhelming evidence of a genuine emergency and the like should this kind of stuff even be countenanced. And even in a genuine emergency, much of it is still questionable. Like World War II was a genuine emergency or genuine war, invasion, and so forth. But the detention of Japanese Americans was still wrong. Price controls were still wrong, and so on.
Well, thank you for that. Forceful as ever. I'm going to ask all my students to join me in thanking you for the first part of this. We're going to take our usual 10-second break, and then we'll be back with a private discussion. Again, thank you so very much for taking the time to do this. It's wonderful.
Thank you.